Um, Good evening, everyone. Thank you very much for coming here this evening to yet another great event of the Human Rights Lawyers Association. And thank you very much to Freshfields for their generous hospitality in hosting it. We are here to talk about a fascinating topic, if slightly prematurely, but we'll talk about that afterwards. I have been reminded throughout this entire process of EU accession to the ECHR of the Bismarck quote, which I now gather is apocryphal, and he didn't say it at all, about laws being like sausages. You don't want to see them being made. And you certainly didn't want to see EU accession being made because it was the most wonderful example of sincere cooperation that was neither sincere nor cooperative. But we have we have two wonderful experts and a hologram here at the moment, but I think we can probably blame a Bello Anglia, or whatever they're called, trains that come from Colchester, for the absence of Steve Pearce, who doubtless will turn up because he always does. But first of all, we have Tim Jewell from the Cabinet Office, who's been head of the legal has had the responsibility for the legal aspects of almost every government department, most recently at the Ministry of Justice, but now he's right in the thick of it, so to speak, but perhaps without the rich vocabulary, in the Cabinet Office. And he's going to talk about the nuts and bolts of the process of EU accession to the ECHR. And then we have Marielene Dimitriou, who is a practitioner at Brick Court, who is not a Greek lawyer. She's a lawyer who happens to be Greek, but she read law here in England and has been practicing at Brick Court, and her practice specialises in EU law and in public law and in the European Convention on Human Rights. And she's clearly, and I can say this with my venerable white hair, far too young to be a silk, but she is, and that's entirely due to her excellence in her field. So we're very lucky to have them. And when he turns up, we'll also have Steve Pearce, who's the Professor of Everything European at the University of Essex. So without further ado, I'll invite Tim to kick us off by starting. Thank you.
Thank you, and thanks for the invitation to be here. It's a real pleasure. Oddly, I was here last week, this time, this building, this day last week, to listen to Lord Chris Smith, who's giving the UK Environmental Law Association annual lecture about making a case for the environment. We get about us, government lawyers. And it was really interesting, if rather scary. But the reason I mention it is because I was thinking of that great sort of environmental TV moment when David Attenborough presented the whole of human history as a clock. And the imminent threat of climate change is something that we therefore have to face in the next 2 seconds, or we're all dead. Do you remember that? So all of human history, and there's that little slither yet. And I was trying to translate that to the process of EU accession to the European Convention on Human Rights. Sadly, we're not in the last 2 seconds of the process. But what I want to do, I say sadly, I'll come to my civil servant caveats, if I may, in just a moment. They're quite long. What I want to do in sort of quarter of an hour, 20 minutes or so, is just give you a flavour of the process by which we have come to where we are, wherever it is we are. But at least it's like that old joke, isn't it? Sort of much better informed, but none the wiser. So, with that sort of rather feeble introduction and sort of dubious comparison, quite a lot of obvious stuff. Sausages, laws, yes. The difficulty is that what we're talking about sort of different varieties of sausage, aren't we? We're not talking about just sort of the good old sort of hydrogenated offal tube that is the British sausage, but various forms of Euro and European sausage. I hesitate to take that sort of any further. What it is a genuinely highly complicated, multi-layered policy and legislative challenge. We're trying to fit together systems that weren't in the conception of each other when they were created to work to find some unified whole. That's one view. Of course, we're relatively familiar with each of those, sort of UK human rights practice, for example, not least since 2000 and the coming into force of the 1998 Act. But of course, increasingly sort of fundamental principles of EU law and the Charter, which of course is ever and increasingly present, not least in domestic litigation, as well as the political discourse here, and the Strasbourg system as well. So what we're talking about is how you blend those three things together. Here's Steve. Excellent.
Welcome.
Oh, thanks, Steve. So what I just wanted to frame then, if running one legislative process is tricky, running three legislative processes together is trickier still, not by a factor of three, but by a factor of various multiples of three. The caveats, just to get them out of the way, obviously I'm a civil service lawyer. I don't speak for the government. Similarly, I'm not responsible for policy, which everybody's rather grateful for, because I don't think lawyers, if you know, there's only, no, I won't go there. Lawyers shouldn't be responsible for policy as a general rule. I'm an ex-academic as well, and I've begun to realise that ex-academics are a bit like ex-smokers. You know, there's nothing as bad as there's no non-smoker as bad as an ex-smoker. But one of the things I've been pondering lately is, of course, that academics have the joy and privilege of how can I put it, sort of exploring both sides of the law policy boundary in a way that government lawyers don't. So I'm going to be talking about law and process and legislating so far as the EU Convention, accession to the Convention is concerned. As you've heard, for the last 3 years, I've been leading the Information and Human Rights team at MOJ. That's a small cog in a very big wheel in the EU accession process, as you'll see. And I've recently gone to the quiet backwater that is constitutional reform. Big mistake. Obviously, the care and attention that is being devoted to EU accession can be stood in comparison to the care and attention that is being spent on constitutional reform. The design brief, dodgy building metaphor, let's just get a bit of law out of the way. Article 6.2 of the TEU, the Union shall accede to the Convention, and such accession critically, he added by way of commentary, any views I inadvertently express are my own, shall not affect the Union's competencies as defined by the treaties. That's really, really, really important. Protocol 14 ECHR, which came into force a little bit later, as we'll see, lets the EU accede to the Convention. The thing to look at, as we've discovered, those of you who've been following the European arrest warrant discussions in the last few weeks will appreciate the importance of reading the protocols to the treaties as well as just the treaties. Don't forget protocol number 8 to the EU treaties, which says a bit more about what Article 6.2 should do. And it makes some certain limitations, a matter of EU law, on what the accession agreement shall do. And I'll flesh out the various bits of paper in a mo. Yes, and these two, and I shan't read them, you can read them. There's some pretty big limitations and important principled limitations then on what accession can do. It must preserve the specific characteristics of the Union. Again, we have this mention to not changing the competencies of the Union. And then we've got some stuff there about affecting the situation of member states in relation to the Convention. So really, really important stuff. And our foundation for our vision, our sort of Kevin, what's his name, grand design vision of a new Europeanized human rights superstructure architecture. Some design elements into our new construct then. Again, with apologies, the sort of sucking egg stuff. The Council of Europe does much more than the European Convention on Human Rights, obviously. But it's critical in organisational and process terms because we shouldn't, as so often is mistakenly the case, confuse the COE with the Convention, albeit it's at the very heart of the Council of Europe system. We need to recognise that this is a slice of what the COE does in institutional as well as legal terms, and part of the accession challenge is to enable the EU to participate in but a slice of what the COE does. That really does matter quite a lot, not least because the COE is quite expensive. The EU isn't a state. It's a statement of fact, not an opinion. It isn't a member of the Council of Europe, and it's not going to become one as a consequence of this or in the immediate future otherwise. I mean, this may sound like noddy stuff, but it really does matter. There are 47 parties to the convention. There are 28 EU member states. Simple majorities don't really work, as we'll see. More ECH parties are EU member states than are not. And if you're a non-EU state party to the convention, this really matters, of course, when it comes to, let me think for a moment, the enforcement of judgments by the Council of Ministers under Article 46. Implementation of judgments, I should say. Again, sucking egg stuff, but really important. And as we've seen, the EU has only the competence its member states have conferred upon it. And in particular, of course, EU member states will continue to participate in the other bits of the Council of Europe architecture, not affected by EU accession to the European Convention, in their own right, subject to the usual European rules. If anybody wants to talk about external competence, then there are people in the audience who know about it. The intention is to disturb neither of those systems. It's to allow them to continue to run in the way that that they have been running, but with filling the gap, and others may have views on the size or serious or significance of the gap, filling the gap that will enable the EU to be held account to the same standards and the same rules as other its member states are by the convention system. And that's, in short, I suppose, the principal purpose of this whole effort, which is a very considerable effort. Accession required, now I'm going to turn into the nerdy Whitehall lawyer briefly, as if, I've got out of that mould yet. Accession requires amendment of the convention. The accession agreement will become part of the convention system. They interlock in a very carefully balanced way. But of course, that necessarily also means that the agreement must secure the approval of all of the parties to the convention, all 47, and so approval by each party, including us, and including every other EU member state, in accordance with its own constitutional arrangements, and EU approval too. So even once we work out what it is that we're seeking to agree to, everybody has to actually agree to it. And that's a relatively cumbersome process, I think it's fair to say. For those of you who haven't read the EU Act or the Constitutional Reform and Governance Act, there are some quite tricky UK processes before we get to the rest. I may come back to the rest if people are interested. EU approval requires unanimity, so every member state must agree, but then the Strasbourg process is critical too. I'm reminded at this point, before I move on to, so what does that all mean and where does it take us? It's an aphorism much loved, I think, of one of my colleagues who's here, that in Europe you negotiate to reach a deal, in Strasbourg you discuss to reach an agreement. The culture of these different organisations is part of the legislative challenge in bringing together these systems. I make no comment on Westminster or Whitehall. No, I seriously make no comment on Westminster and Whitehall. So the project plan, to extend almost a breaking point to my architectural metaphor, is just to give you a flavour of how we got here and the timing. March 1996, the then Commission sought an opinion from the European Court of Justice as to whether or not the EU had competence to accede to the Convention. No, said the court. It's of constitutional significance going beyond the then sort of sweep up Article 235, if I can call it that, provision. Seems like quite a long time ago, doesn't it, 1996? It is quite a long time ago. 2009 then, the necessary treaty provisions came into force, enabling, or in fact requiring, as we've seen, it's a duty, discuss the difference between a duty and a power in this context, answers on a postcard. The duty comes into force. May 2010, the serious things get rolling, particularly on the Strasbourg end, of course. The EU Council, having authorised the Commission to negotiate with Strasbourg on behalf of the EU, discussions began in Strasbourg about what accession might look like. That was entrusted to an informal expert group through the Strasbourg architecture, to come up with a draft accession agreement, how you might engineer the modalities, to elaborate the modalities as the language goes. It's a curiously useful phrase, word modalities, actually, because it genuinely crosses European borders. But if you ask anybody, they don't really know what it means, the way of doing stuff. It's one of those glorious European words. It's surprisingly useful, but people look at you in a very peculiar way. That's, if they let me out of the building on anyway. This is the second half of the project plan then, which brings us almost up to date, October 2011. Draft legal instruments were submitted at the Strasbourg end. Again, bear in mind we've got a whole series of interlocking negotiations going on here. And at that point, the Committee of Ministers in Strasbourg said, OK, your expert human rights group can negotiate with the EU. So you've got a Strasbourg proposition as to how the EU and the Strasbourg systems might interlock. And they're given license at that point to talk to the EU about it. So this is where 47 plus 1 comes from, the 47 member states, parties to the convention, plus the EU. The EU negotiators acting under license from the EU Council in the usual way and therefore representing the EU en bloc. An astonishingly quick time later, a short time later it might be suggested, draft revised instruments were agreed at negotiator levels. To say that the EU was ignoring this process would not be right, but relatively quickly afterwards a draft revised instrument emerged, or series of instruments emerged. And then the Commission decided to ask the Court of Justice what it thought and about whether the accession agreement is compatible with the treaties. Just over a year ago, there was a hearing in May. I wasn't there. You were there. There were lots of people there. Member states had the grand sum of, I think, 10 minutes to make their oral representations. That's just how the EU works. You usually get 20 minutes, lavish. Very heavily paper-driven process, of course. And we're expecting the court to give its judgment on the 18th of December. Hence, this, it's very exciting. What sort of Christmas present could you expect beyond that? 18th of December. The court is depressingly unleaky, in my experience, which is a bit of a shame as a government lawyer, because you like to steal a march if you can, but we haven't been able to. I did hear somebody who will remain nameless say it's been suggested the opinion is going to be innovative. As civil service words go. Anyway, but it's courageous. Anyway, so we'll see. So we're expecting, of course, that's not the whole story. That will be the court's opinion on the compatibility of the draft accession agreement with EU law, with the treaties. Let's see what they say, because, of course, if the court says, actually, and this is a bit dodgy, I'll come back to some of the particular features of concern, then that begs an interesting process question about how you fix it or align it with what the court has to say. So that's the process in outline, and it really is an outline so far, quite a long one, which the next key stage is the opinion of the court. I really am going to extend my dodgy metaphor now. Issues arising on site. When you get building work done, things crop up. I say this, I'm having all of my bedrooms plastered in the same week. It turns out that's a really, really bad idea. But anyway, that reminds me of this. Some issues, accession to the protocols, not just the convention. The starting point, of course, and as reflected in the agreement, is the EU will accede to all the protocols to which every member state in which every member state is participating, and not the others. Issues about appointment of the singular EU judge to the Strasbourg Court. Not uncontentious for obvious reasons, because there are lots of EU member states who have an interest, and the identity of Strasbourg judges is a matter of high interest, as we know. Particularly, and this is, everybody knew that this issue would arise, is how you manage the participation, the day-to-day management of the participation by the EU in litigation. I've been a government lawyer for a dozen years or so, and before I sort of was thrown out of academia, metaphorically speaking. I'm always incredibly impressed that states, whether it's this one or others, can actually bring themselves to a point of a focused contribution to a very specific piece of litigation in an international fora. I think that's a real credit of organisational skill, actually, aligning sort of the great departments of state on a singular point. There's a book in there somewhere, which perhaps one day I'll write, but nobody will buy it, sadly. But imagine doubly so how difficult it is to corral those points into a single EU position in key litigation before the Strasbourg Court, which might blow back on those member states. That's the real sort of litigating and sort of legal policy challenge of this process, it seems to me. It's not the only one by any means. And novel forms of participation as co-respondent. And this is a really one to pause on, actually. As I mentioned earlier on, a key purpose in all of this is to get the EU in the same place as its member states, in that its institutions should comply with the convention obligations. But of course, the division of competencies between the EU and its member states is tricky and contested, not least amongst the member states and between the institutions themselves, of course. And so when you're confronting that question in a Strasbourg court, you need an extra mechanism to enable everybody who might potentially have an interest in the outcome or the ultimate resolution in that distribution of competencies to play in a wrong word, you get the gist, to participate in the proceedings. So a new co-respondent mechanism has been fashioned to enable, where there's a question mark as to who has competence to do what, or whose responsibility it was to come up with the allegedly dodgy rules in the first place, or actions or behaviours, for both the EU and its member states to participate in the litigation. It's sort of gap filling in a way. So in actions against the member states where EU law is an issue, the EU can participate as a co-respondent. Similarly, in actions against the EU where the treaties are an issue, the treaties being a matter for the member states, of course, the member states can participate. So you have these reflective participating obligations and opportunities, all in the gift of the court, in accordance with so the accession agreement says. So novel forms of participation in an uber novel process. Similarly, of course, and this was an issue, or at least an undercurrent at the hearing, as I say undercurrent, riptide possibly, the prior involvement of the CJEU, which of course has ultimate authority to determine what EU law is. And of course, that's a key tension here. So there's an issue about not only sort of treaty base, but also the practical the practical relationship between the Luxembourg court, which of course has a license to dictate decide what EU law is, and the Strasbourg court, which has principal responsibility for interpreting the convention. So this mechanism has been designed, if the ECJ hasn't looked at a particular point, to get it to look at it before the Strasbourg court does. So that's novel too, allocation, non sort of standard relationships between courts. I've alluded to allocation of responsibility for giving effect to judgments already. The starting point is that responsibility will normally be joint between the member states and the EU. Again, for the same principled reason that it's not for the Strasbourg court to tell the EU and its member states how to divvy up competence between themselves. And then implementation of judgments. If, heaven forbid, that there were to be an adverse judgment against, I don't know, the UK or something, how one might go about adapting what would otherwise be an en bloc EU vote, which could dictate the outcome of all decisions in the Council of Ministers. I mean, non-EU member states seriously and rightly concerned about the balance of power in implementation of judgments. So there are novel and quite complex and finely nuanced modified majority voting rules hidden away in the annex, but they're Annex 3, critical stuff. Now, what I haven't mentioned is the final act in this sort of almost Wagnerian sort of process, which is the EU internal rules. As if we didn't have enough layers of stuff. Convention, accession agreement, domestic implementing measures, new novel forms of participation. The EU has to decide internally how, for the reasons I've described, it's going to manage the process of litigation in the Strasbourg court, and that's going to need internal rules in whatever form. There are lots of possible forms, directive, whatever. We don't know what's going to be in those yet. They haven't been proposed. It's the Commission's job to propose those. I mean, it's fair to say that this interlocking system, and I don't want to make it, the civil service, and I exclude myself from this, is really good at coming up with solutions to very difficult problems quickly. Has anyone read the Smith Commission report published this morning? Very exciting. I think it's within within the capacity of the European institutions to come up with some pretty complicated rules. But let's not kid ourselves, they are going to be complicated rules about how this works, and they're going to be highly contested, because how you decide what your case is quite an important question, isn't it? Ken Clarke, when he was Lord Chancellor, said that about them. That begins to scratch the surface, frankly. As I say, there aren't any internal rules yet. Of course, in the context of the hearing and in the context of negotiations at both ends, there have been discussions about what might be in those internal rules. In fact, the House of Lords EU Scrutiny Committee, in its sort of hidden away on a back page of its website, if that's a description that works, said something about this. It's worth reading that report just to get a gist of the House of Lords view. The House of Lords thinks that the content of the internal rules is a critical part of the whole package, without which you can't agree any of the package. So the accession agreement, all the institutional arrangements, including how the EU works, it hangs together because of the necessary dependencies with it all. That's quite compelling, isn't it, really? Some might say. Because internal rules are a legislative function, not a judicial one, and therefore a